Good evening and welcome to another episode of Awaaz in Focus, a part of Azad Awaaz. Azad Awaaz is a monthly patrika that focuses on marginalized sections of the society, whose voices are often muted in the cacophony of flashy mainstream media discourse. When referring to marginalization, this platform does not aim to restrict itself to traditional focuses on social aggregates like caste and race alone, but aspires to include a discussion on class, gender identity, environmentalism, representation, and intersectionality. In this issue of Patrika, we would like to focus on to understand the ways in which development, as we fashion, has remained exclusive with special emphasis on the condition of manual scavengers. This would also raise a question of thinking of the development process from the viewpoint of marginalized population and the domination of privileged perspective in the development thinking. This will cover themes like caste, policy making, manual scavenging, etc., surrounding the issue of manual scavengers. Therefore, for Awaaz in Focus, we would focus on exploring the laws and provisions in place for manual scavengers and analyze their insufficiency. It will delve into topics like understanding the policy making perspectives over the issue, attempts to reform the laws and policy, loopholes in the current provisions, way forward to inclusion of needs and covering the gaps in the existing system, and so on. Today, with us, we have Mr. Samuel SathyaSeelan, who is a doctoral fellow at Center for Informal Sector and Labor Studies, JNU, New Delhi. Samuel has undertaken his ethnographic research on the sanitary workers in Bengaluru. The study looks into the nature of work and living condition of sanitary workers engaged in sewer cleaning and explores the relationship between urban space, sanitation, and untouchability, which shaped the sanitation management of the city. He has worked with organizations like Center for Child and Law, NLSIU, and the like as well. Apart from his regular work, he has also taken up legal advocacy and has written modules for IGNO and MHRD courses and also authored articles. Thank you so much for joining us here today, sir. So let's first talk about the historical nature of the problem and the inefficiency of the laws that deal with it. So I read your article, sir, and in that article, what I could figure out is that be it the most contentious prohibition of employment as manual scavengers and Rehabilitation Act 2013, or other reports like Standing Committee on Social Justice and Empowerment, they have always left loopholes like the vagueness of the term protective gear, leaving equally vulnerable communities like sewage workers out of their ambit, focus on liberation, not realizing that it would not help them rehabilitate unless there is a new opportunity for safe employment that is created, and also the vagueness of the retirement scheme and compensation, which renders it practically ineffective. So, how do you see these flaws sticking around for a long time? And why do you think this has been a case despite several organizations working towards ending this subhuman occupation?
Before we get into the legislative framework and the aspects concerning the 2013 Act, let us understand what is the existing patterns or the toilet systems that are existing in India. One, we have house latrines connected to the sewers. We have house latrines connected to the septic tanks. House latrines connected to the STPs, especially now the high-rise buildings have their own STPs, which has to treat their own sewage thing within the apartment. Then we have public latrines, public toilets, because we see, especially in the areas where slums and where communities which don't have access to toilets. So we government provide such services. Then we have public and community toilets in slums. Then we have also government private establishments and schools connected to sewer network. Then these are the different kinds of patterns that you can see in most of the cities. If you see in the rural areas, we usually see the septic system, or we have now, because after the Swachh Bharat, we got the twin pit systems coming in place. So these toilets which are constructed has a purpose now. That is now government me just a minute. Yeah, this sanitation or the toilet system connects for emptying and disposal. Then we have the convenience and maintenance of these toilets, the treatment, and finally the workforce who are involved in these toilet system. That is now in a city like Bangalore and Delhi, we have a sewage connection. So all the households are having flush latrines, and these latrines are connected to the sewers. And the services required here is the sanitary workers who need to help for the smooth flow of these sewage into the main stream, and finally it leads into the STPs. So when we when we see the open defecation system, there we have the manual scavengers who have to literally carry the excreta in their hands, and then they shift it into the particular location. But here, so each type of toilet which I listed has different forms of work involved. For a sewerage, we have different kind of type of workers who are involved. For septic tank, we have different kind of workers involved. For work in STPs, we have different kind of because the nature of work is different in these. So even in the twin pit systems, there is 6 months and annually the pits are clean. So we have separate workers who engage in that particular. So not all workers engaging in the same different kinds of systems and sanitation schemes, and we have different kinds of workers involved. So what the 2013 Act focuses on the complete eradication of open defecation, the toilet which doesn't have flash latrines. Now the MS Act has, if you look into the MS Act, we see certain parts in that legislation. One, apart from the definition, we have the identification of insanitary latrines. Then we have the prohibition of insanitary latrines and employment and engagement as manual scavengers. So you are identifying the insanitary latrines. Government demolishes those insanitary latrines and constructs the flush latrines. Now, after that, we have a prohibition of insanitary latrines, and apart from that, engaging of manual scavengers is also prohibited. Then we have identifying these manual scavengers who have been prohibited from work to be rehabilitated. So the legislation gives you a detailed process of how this a one-time cash assistance of 40,000 rupees provided, then providing an employment to one member of the family, another housing, education. All these are being discussed in the legislation as part of the rehabilitation package for those manual scavengers who have been identified. So now currently we have a data saying that 53,000 total manual scavengers have been identified through the surveys. We have seen that since 2012, we have seen number of surveys being conducted by the central government. But every time the civil society organizations, there are found a lot of discrepancies without the identification of manual scavengers. I already said that even the civil society also had a lot of problems with regard to the definition. Because of this definition, there was also problem in identifying the manual scavenger, because there is also problem of self-declaration as well. And it is a process where the manual scavenger has to go and declare himself before the district commissioner, telling that he's been engaging manual scavenger, and he has to prove himself. And there is also a process which has been given in the it's a very lengthy process that has been given in the legislation in order to identify and declare who is a manual scavenger. Apart from that, then we have the identification of manual scavengers both in the urban and the rural areas. So there is a different kind of provisions given for the urban and rural, as well as the rehabilitation provisions connected to them. Then after that, we have the implementing authorities who are going to implement this legislation. So we have the district commissioner, who is the nodal officer for the overall implementation of this MS Act. The problem here is the district commissioner, who is also the head of the district, also acts as the head of the vigilance committee. So it leads to contradiction. It's a conflict of interest, because the person who is implementing is also a person who's going to penalize those workers, officials who are hiring manual scavenging. So in the Act, there is a provision for penalization of officials who are engaging workers as manual scavengers. But if you see, in most of the in the villages and rural areas, as well as the urban areas, cities, it's the local bodies which are hiring the manual scavengers to clean the land. So in that case, it is the district magistrate himself becomes responsible for hiring the workers as the district in charge. But he is also being given the power for penalization. So it is a contradiction. So that is also been one of the amendment which many of us are asking that has to change. Then we also have a number of committees in the legislation, that is the vigilance committee. We have the central monitoring committee as well as the state monitoring committee. State monitoring committee is usually headed by the chief minister, and the central monitoring committee is headed by the minister in charge of the social welfare ministry of social justice. So if you get to read the provisions of these committees, you will get to know the composition and how these committees are. But if you ask me whether the committees are formed and the committees are actually not functioning, that's what. For example, I'm coming from the state of Karnataka. The committee was formed very long back, but they hardly met twice since 2013. The members, even for example, many of the social workers who have been also nominated to the monitoring committee, they themselves have said that the committee is not functioning. Apart from that, we also have the National Safai Karmachari Commission and the State Safai Karmachari Commission, which has been given the responsibility to overall monitor the implementation of this legislation. So the commission at the national level and the state level. In case the state doesn't have a Safai Karmachari Commission, then the SC/ST Commission or the Human Rights Commission are being given the powers to monitor till the Safai Karmachari Commission has been constituted. In Karnataka, we have Safai Karmachari Commission, but some states don't have Safai Karmachari Commission, like Tamil Nadu don't have. So in that case, we have the Human Rights Commission or any other provision that the state government comes out with regard to the monitoring of the which has a mandate under the legislation. Now let me get into the point which you were earlier asked about the railways, Indian Railways. I already said that under the legislation, manual scavengers, those who are engaged in cleaning of the tracks as well as the toilets in the trains, are considered as manual scavengers. So government also has a responsibility to prohibit that in the Indian Railways. So Indian Railways is the largest employer of Safai Karmacharis, manual scavengers, and are employed almost entirely on contract labor to clean the human excreta of the railway tracks at the stations. The government has been denying the employment of people as manual scavengers. The affidavits in the courts by the government suggest that except a few trains, the railways does not employ any technology to keep the thousands of toilets and kilometers of tracks clean. The excreta dumped into the tracks have to be manually cleaned up. The whole responsibility lies with the railway contractors because it has been outsourced. Usually cleaning of these tracks and toilets are being outsourced, and we have the contractors who do it, and they recruit a lot of huge amount of workers for cleaning these toilets and the tracks manually. And the whole responsibility lies with the contractor who also employs these workers to perform such work without any proper protective gears. The railways have got in few technology solutions recently, such as the concrete washable apron, controlled discharge toilet system, bio toilets, then vacuum toilets, which are in the flights, have also been introduced, but in a very limited scale. But very little information is available regarding its implementation with regard to the technological upgradation in the railways in order to prevent manual scavenging. The Supreme Court judgment in 2014 observed that the state is duty bound to end manual scavenging on the tracks in a time bound strategy. That is the observation made in the 2014 Supreme Court judgment. So already there's a mandate under the law and also reiterated by the Supreme Court in the 2014 judgment for complete eradication of manual scavenging in railways. So who are these laborers working in the railways as manual scavengers? It's the same Dalit community, the marginalized community who are being recruited for cleaning this, and most of them are contract workers, outsourced workers. So which is actually this contractualization itself is an exploitation. So we have huge amount of workers engaged, and there is no data available. So how many workers are employed? At least we have data regarding the number of sanitary workers working in the Jal board or in the municipality. But in railways, there is no kind of data available. How many exact workers are engaged as manual scavengers to clean these toilets and that on the railway tracks? So that is my observation regarding the railways. Now, going into the argument, what is Swachh Bharat doing here? So if you go back to the legislation, the Manual Scavenging Act, we see that we have the provision for the identification of insanitary latrines and demolishing them and converting them into flash latrines. That is the ultimate aim of the Manual Scavenging Act, for complete eradication of the dry latrines. So the Swachh Bharat, before Swachh Bharat, we have Nirbal Abhiyan during the UPA government. They started constructing the toilets and also we have the twin pit systems that has also been part of the Swachh SBA. So these schemes that are under the Swachh Bharat Abhiyan are more of symbolism, because that is what I personally understand, and little to do with improving the lives of the marginalized community. See, one aim of the eradicating manual scavenging is to demolishing the insanitary latrines. But there is a question mark: what happens to these workers who have been moved out from as manual scavengers? So there is a systematically laid out provisions regarding how the workers has to be rehabilitated. If you read the Supreme Court judgment in paragraph 14.4, it reads that rehabilitation must be based on the principles of justice and transformation. It's not just liberation, it is transformation. So what is a transformation? It is not just providing a 40,000 rupees one-time cash assistance and giving them a skill development and leaving them providing them loan. That doesn't suffice. That is not sufficient for the workers who have been working for decades as in an occupation which is so dehumanized. And you see, because they have already been engaged in this occupation, that is already on their body, meaning it is they have been engaged in impure occupation. Even if they want to go for find any alternative employment, if they get to know that these workers were engaged as manual scavengers, they're not able to get any kind of better opportunities. So what happens if they fail to get proper livelihood, better work opportunity, they don't have proper assistance from the government? Many people have come back to the same occupation. I have one case in Bangalore when, as part of my field work, I was engaging with them since 2017. I interacted with a bunch of workers in Johnson Market, one of the famous markets in Bangalore, where they were engaged in private sanitary cleaning of the manholes. They were not employed by the Jalbo. They were privately doing it. Then when I was trying to discuss with them, I found that they were actually manual scavengers. They were identified by the government. They were issued ID card. They were given one-time cash assistance. They were provided a skill development program, loan, but they could not able to sustain their livelihood because the activity that was the occupation that was that they gave after the skill development program was selling of tomatoes, vegetables, which was a perishable product. So they didn't have the facility of refrigerators so that they can store them. What happened? Finally, they went into debt because they had to repay the money. They could not repay it. Finally, they came back because they didn't have the option of going back as manual scavenger. They started doing manual cleaning of septic tanks and sewer manholes. So I always look at the judgment which says the rehabilitation must be based on the principles of justice and transformation. When we talk about justice and transformation, it should be holistic, and it should also see that the coming generation of that particular community, of the family as well as the community, should move out from this occupation. That is what the Act also wishes. The aim of the legislation. So coming back to this Swachh Bharat thing, the Sathyaseelan has actually invisibilized in the Swachh Bharat mission, who are laboring every day in keeping the country clean. The Swachh Bharat mission is completely silent regarding the workers' struggles and problems, and the interest does not fit the frame of reference in the Swachh Bharat movement. That's what I feel. The Swachh Bharat objective, if you look at the Swachh Bharat mission objective and also look at the objectives of Amrut. See, Swachh Bharat is for rural specifically of eradicating the insanitary levels. Amrut focuses on septic tanks and creating sewerage system for the cities. So we have the two things, not just Swachh Bharat. We have to also look at Amrut scheme. So if you look both, the objective has conspicuously silent, and there is no mention of the practice of manual scavenging and hazardous cleaning of septic tanks and sewers. So if you open the page of Swachh Bharat Mission or Amrut, they don't have any objective regarding the elimination of inhuman occupation, of hazardous occupation, as well as Swachh Bharat Mission doesn't say that they have not declared that they're going to prohibit manual scavenging. It talks about the open defecation. It talks about behavioral changes, but that doesn't make the eradication of manual scavenging as an objective, including Amrut. Okay. So rehabilitation and compensation. There are two different things here we need to understand. In the legislation, it talks about rehabilitation. but it doesn't talk about compensation. Compensation comes only in the case of sewer and septic tank cleaning. Workers who die or exposed to hazardous poisonous gases, or there is a case of death and accidents, only then the compensation comes in. So the compensation, the component of compensation is silent in the legislation. So only it is in the Supreme Court judgment. If you again come back to para 14, 2 and 3, it talks about the provision of compensation. And what is the compensation? If the practice of managed scavenging has to be brought to a close and to prevent further generations from inhuman practice of managed scavenging, rehabilitation of managed scavengers is needed. That is the first point that Supreme Court makes. So rehabilitation is the one important component. And the second important component is about compensation. That it talks in 2A. It says sewer deaths. Entering sewer lines without safety gears should be made a crime even in emergency situation. For each such death, compensation of ₹10 lakhs should be given to the families of the deceased. That is sewer death and septic tank. Further, if you see again 14.3, paragraph 14.3 says, identify the families of all persons who have died in sewer work, that is manhole and septic tank. It's mentioned in bracket since 1993 onwards, because the first act came in 1993. So and award compensation of ₹10 lakhs for each such death to the family members depending on them. So the compensation which is silent in the MS Act is, there is a provision made in the Supreme Court judgment. So now what has happened is there was few cases of death happened in Bangalore during my field work. So the worker had passed away because he died because of he had fell inside the manhole, and one worker was got hit by the jetting machine. So what happened at the mortuary, an FIR had to be filed. Only if the FIR is filed telling that this worker died because of sewer death, only then is entitled for the 10 lakh compensation. And the police is asking the 10 lakh compensation doesn't mention in the MS Act. So how can we ensure that 10 lakh rupee compensation be given to the worker? So the activists have to sensitize the police officers, telling that there is a Supreme Court judgment, and they take the copies of the Supreme Court judgment and give it to police officers and say that they are entitled to. Then the contractor or the local body then make an assurance that the compensation of 10 lakh rupees will be paid. But recently there's a study that has been taken by Isaac Bangalore, where they're studying about the deaths and what is the prosecution that is, level of prosecution has happened regarding to the sewer death and septic tank cleaning. It's zero prosecution. See, filing an FIR itself is a big challenge, and filing an FIR also has a problem, because the police officers should mention it is culpable homicide, because it is a death under the IPC section 304. Then again 304B. Then again they also need to mention about the provisions under the Supreme Court and the MS Act, that it is prohibited under the managed scavenging. Unless and until these components are at the police authorities who are sensitized, the whole case fails there in the first stage itself. So how can we expect the case to be taken forward? Then after filing the FIR, then the investigation should begin. Then we have it is found that the prosecution department itself doesn't have the full data with regard to the 80 cases of sewer death and septic tank cleaning in Karnataka from 1990. There are 80 cases totally in Karnataka. So in all cases, not in one case, the case has been taken up in the trial court. Only the FIRs are filed, and certain level of compensation is being paid. Certain cases, there's bribery happening while when the compensation has to be paid to the deceased family. There is also problem of identifying the family, because once immediately the worker dies, the workers, most of them are migrant workers, so they go back. So the government fails to identify the families to award that compensation of that rupees 10 lakh. So many a times only a certain amount has been provided as immediate relief of, like for example, 50,000 rupees, but the full amount of 10 lakh compensation is not being provided to the family. Some families are still waiting for that compensation. So a lot of loopholes because it is left to the district in charge. So these are the limitations that that I like to share from the field. And the second thing which from the beginning I spoke about the toilet system, the different toilets that are working in the rural and the urban setting. So toilet, who is going to clean the toilet? That is also a question. Whether it is inside the house or the outside the house, or it is a public latrine or a community latrine. If someone has to clean it. And mostly it has been cleaned by the Safai Karamcharis. The Swachh Bharat mission talks about one of the objective. It talks about the behavioral change of the people. The mindset of the people has to change. That's what the Swachh Bharat mission, one of the objectives. So behavioral change is not just using toilet, but also the mindset of those who consider cleaning the toilet as impure and polluting. And the callous attitude of such class and caste groups expect the Dalits to clean them. Hence, the root cause has to be located, and not just the individual behavior. We need to break the link between the caste and occupation before we set out to achieve the Swachh Bharat object and the goals. So construction of now we are in the mode of construction toilets, and we have targets. So we have come out with these number of lakhs of toilets being constructed, but who's cleaning? So we see majority of the households, the toilets are cleaned by either by the domestic worker or the Safai Karamchari. It's not the people inside the house or the families who are not engaged in this, because that attitude has to change. So behavioral attitude is not just you are bringing the structure inside the house where you use for defecation, but it also who is going to clean that. The number of increase of toilets also mean that a new form of labor is being coming up. So you're trying to bring in a new kind of we are giving up managed scavenging, but we are trying to bring in a kind of different form of toilet cleaners. That's what with regard to Swachh Bharat missions and the objective of bringing the thing is Swachh Bharat is linking with the MS Act because it has a mandate, because it has to eliminate the insanitary levels and demolish them and come out with the flash levels. But increasing the toilets, we should also understand that it also creating a cadre of people who are going to engage in toilet cleaning. That's what I think. And there is a very interesting article by Ravi Chandra Patran, who has written an article titled "Politics of Space of Indian Toilet: The Extreme Binary from Untouchable to Touchable." I think those interested can read this article. It talks about the structure of a toilet, understanding toilet within, and he talks about multiple things, how toilets have been visioned, how it has been located inside the house, who's cleaning it. So it's a very interesting piece. So in that context, I just wanted to make this observation. Now, the other thing which I would also like to point out is, going back to the legislation, I was explaining in the beginning the kind of interventions that are in place. That is interventions and grievance redressal mechanism for the prohibition of manual scavenging and regulating of sewer and septic tanks. If you see the title of the act says the prohibition of manual scavenging and the Rehabilitation Act. But there is no mention of Safai Karamcharis, which includes the septic tank cleaners, the STP workers, the sanitary workers, toilet cleaners, even the solid waste management. None of these workers, even sweepers, are also engaged in unclean occupation, cleaning the toilets. In many places, sweepers clean the public bathrooms. So they are not, the definition tries to limit to manual scavenging, and here and there they kind of making certain provisions for prohibiting the hazardous cleaning of septic tanks and sewers. So when we look at this, we look at the legal intervention. We have the 2013 Act. We have the rules. We also have the SCST Act, SCST Atrocities Act 2015, which makes provision for those who have been compelled to do manual scavenging and sewer cleaning because of especially the Dalit community. So there is a provision to safeguard their rights. If the worker is resisting that he is not going to engage in this and he's been forcefully be pushed into this, especially it happens in the rural areas. So there is a provision under the SCST Act which also penalizes those who are pushing these workers to engage in these kind of unclean occupations. Then we also I already explained about the national and the state commission, Safai Karamchar Commission, which has a mandate under the MS Act, looks into the monitoring of the act, and also it has a responsibility to visit the different districts and to see how these acts are implemented. It also acts as a grievance redressal body. In case of Safai Karamchari or a sanitary worker is being denied of wages or been exploited by the contractor, or he's not been provided with safety gears, or he's been denied of social security benefits, the Safai Karamchari can go and approach the National Commission as a state commission, as a grievance redressal body, and the commission has a power to hear. Though the commission has a limited powers, but it acts as a grievance system for the Safai Karamcharis. And if you ask me whether it's if a Safai Karamchari is a scheduled caste, and I would prefer that that worker should directly go to the SCST Commission rather going to the Safai Karamchari Commission, because the SCST Atrocities Act as a provision for with regard to atrocities and the service related matters. It can hear the cases, and it has more powers and also can give compensation under the SCST Act. Whereas the Safai Karamchari Act doesn't have, the commissions are not empowered with that powers. So there is an option for those Safai Karamcharis, the sanitary workers, septic tank cleaners, STP workers, if they face any kind of atrocity or violations in the work site by the employer contractor, then they can directly go to the SCST Commission. See, this has not been discussed in the MS Act. So MS Act doesn't say that scheduled caste worker should go to SCST Commission, not to the National Commission. So it is silent about that. But if you look at the amendment on 2015, where it brings provision which tightens which gives some kind of safeguard to the Dalit community with regard to pushing them into unclean occupation, this can be used as a tool. Then we also have the judicial interventions. Through judicial interventions, we still see there are a lot of cases being heard in the High Court as well as the Supreme Court with regard to the manual scavenging. One we saw the 2014 judgment. Apart from that, we have multiple other cases. I would also be happy to share those cases. One is judicial intervention, which talks about working condition, protected gears, and mechanization. For example, Gujarat High Court, Delhi High Court, Karnataka High Court has talked extensively regarding providing safety gears, mechanization of the sewer cleaning. So that is one way, which is where though the act is silent, the judiciary is trying to push the state government and local authorities to go for mechanization. There are others. The other judicial intervention talks about the compensation and rehabilitation. I was pointing out section 4, paragraph 14(3), which where the Supreme Court asked the state governments to give a compensation of rupees 10 lakhs, which the MS Act doesn't speak about. So there are, so these are also a way to look at overarching things where we see we have judicial interventions and also judicial remedies. We also legislative remedies. We also have statutory institutions, or we also call it as the human rights institutions, like the Safai Karamcharis and SCST Commission, as well as the Human Rights Commission, where the workers can have, these bodies act as a grievance bodies. Now we also have, which I already explained to you. I think there are human rights institutions. I will just skip that now. Let me come to the mechanization. What is that mechanization? Because we continuously seeing about mechanization in Amrut. We also see the there is a provision under the MS Act, section 33, which talks about mechanization. So the section 33 under the MS Act, it gives the responsibility to the local authority. Who's that local authority? It's mostly the corporations or the municipal corporations. But the question mark is whether the municipal corporations are financially better in procuring such kind of machines, because they're always dependent on the state government for funding. So rather here we see the legislation is trying to push the responsibility to the local authorities. The reason because sanitation was earlier in the central list, which was pushed to the state list during the colonial time, and now the state from the state list it has pushed into the municipal laws. So the sanitation is the responsibility of the municipality and the panchayats. So now the onus of mechanization lies with the municipal bodies, who are continuously facing financial limitations. And each, for example, if you have to buy a jetting machine, it costs you around 30 lakh rupees. And if you take the proportion, for example, my own example, in Bangalore, we have 110 service stations. In each service station, we have around 4 to 5 contract workers engaged in sewer cleaning. And they have 140 plus jetting machines and sucking machines. That is proportionally one machine in each service station. And these service stations cover around 1 to 2 wards, municipal wards. Imagine there are 10,000 to 15,000 households covering one service station. And you have only 1 or 2 machines. And the minimum complaint per day, we get around 10 to 15 cases in the service station for regarding sewer cleaning. And workers are not able to clean all those in the single day. It carries over to the next day, because the certain times there will be only one case which will be carried out the entire day because of the complexity of the case. And there we also find private sanitary workers coming in. We have sanitary workers or the sanitary workers, permanent workers of the municipality or the Jal board. We also have the contract outsourced workers provided to the Jal board by the contractor. We also have private workers who work with the bamboo stick. That is called the bamboo stick, usually for cleaning it. And they do it manually. They enter inside the manhole and they clean. That's what we see in Delhi. In many, if you see old Delhi region, we have people engaging in these kind of manual cleaning of sewers and stuff. And that is there are cases of deaths reported because in those places there is no mechanization. They are not working with the machine. If you ask me whether with machine we can prevent accidents, I'll say no, because recently one of the worker who passed away was hit by a jetting. So nozzle. So it's a precarious job. So therefore, one about mechanization, we have one is the procurement and who's going to procure it, whether it's the state is going to procure it or the worker is going to be procuring, because I'm coming to the last part of the presentation. We see we have a standard operating procedure for cleaning of sewers and septic tanks, which were formulated by the central government in 2018. How this has to be carried forward. So it was published by the Central Public Health and Environmental Engineering Organization, by the Ministry of Housing and Urban Affairs. So the SOP talks about the relevant provisions has been customized for the training requirements of the sanitation workers. So here, it's not just providing machines, but you're also upskilling these workers in order to upgrade themselves so they can start working with the machines. So there is an SOP for how, and also the training requirements are under the Safai Mitra Suraksha Challenge that was launched by the Government of India very recently, including the operation and maintenance of equipment. So they try to provide skill development training, how to use these machines. There is also second thing that is also in this with regard to the National Safai Karamchari Finance and Development Corporation. There's a corporation for the Safai Karamchari. So they provide loan, and the sanitary worker or the manual scavenger who's got rehabilitated, they can procure a machine, and the money will be loaned by the development corporation. So you own the machine and you provide the service to the municipality. That is also one way of mechanization phase that has been happening right now. Especially it's practiced in. So I was talking about Safai Mitra Suraksha Challenge. So this is launched in 243 cities in India under the Swachh Bharat Mission Urban. Challenge the challenge is to prevent hazardous cleaning of sewers and septic tanks, mechanized cleaning to be promoted, on ground assessment of the cities. It is a move that aimed to mechanize all sewers and septic tank cleaning operation by April 2021. So I think that is the target, and all informal workers to be identified by the city to integrate them into formal mechanism in place for cleaning of septic tanks and sewer lines, and linking them with social welfare schemes, ration cards, education for children, entrepreneurship, livelihood opportunities, etc. under this Safai Mitra Suraksha Challenge. And they also created a responsible sanitation authority, and this is appointed through the state gazette notification. The responsible sanitation authority is to maintain 5% of sewer septic tank equipments at their disposal every time. And also creation of sewer entry professionals. That means you're trying to create a sewer commandos. That's what they're proposing. The sewer commandos are nothing but among the sanitary workers, few of the sanitary men and blenders to be nominated as sewer commandos by the local body. Dedicated teams of at least 2 trained persons. So they will be professionally trained, and they will be stationed in each of the local bodies at around 200 kilometers of the sewer length. One team for 200 kilometers. So this is what this is the latest update with regard to the ministry has got the scheme under Swachh Bharat mission with regard to mechanization. Yeah, that's what I wanted to share. So if you need any information, you can ask me so I can clarify.
Yes. So continuing with my question, so like we have seen, as you said, like there are a lot of policies with like different loopholes, and like you told about certain policies which have, like as you said, like the act had the loophole of protective care, but then there was this question of compensation that you also raised, and then all of these policies have different loopholes. Can you like summarize as to how do you think the policy process should go ahead, like from now on, that might be able to address all these issues in a very effective way? What do you think are the elements that can be added to this framework, or like new policies that would be formulated so that we are able to deal with this issue of like manual scavenging in a much effective way?
See, that framework is already there in legislation, because when because many of the civil society organizations were part of the drafting of the law at the initial stage in 2012. So certain provisions were retained, and also been the standing committee's recommendations were also taken to see that it is not about uh, eliminating this occupation, but also to see to it that the managed scavengers who have been working in this occupation are properly rehabilitated. So, and if that's why I see again and again, I'm going back to the Supreme Court line which says about rehabilitation must be based on the principles of justice and transformation. Why? Because now what has happened? Most of the 53,000 manual scavengers were rehabilitated, so were identified, were given only the 40,000 rupees cash assistance, one-time cash assistance. Can you imagine 40,000? Can a family survive with 40,000? It is not possible. And they took a lot of time verifying the verification process. After verification, they send them for training, and they give a stipend of 3,000 rupees and some 2,000 rupees for, in the time when they are in training. After that, they provide them loan arrangements. After loan, and it is the burden is still on the worker, right? So he is not professionally doing this kind of different business kind of occupation earlier, because he's been for years he's been engaged in this occupation. So it takes a lot of time. Also, it also see that the second generation should also come out of this kind of occupation. See, they're also now if you see under that Swachh Bharat mission or the Safai Mitra challenge, why should only the sanitary workers family have to purchase the jet? Or the managed scavenger has already been rehabilitated? Why is you're continuing to retain him in one or the other form of this unclean occupation? Just take him out from this and give him a make us you can start a stores, provision store or something else where he doesn't turn back into this occupation. What so transformation is, you're completely liberated from this, but that is not happening. And now you're trying to retain these community, suppress them again, continue to engage in different form of unclean occupation. So toilet cleaning also, you're constructing lakhs of toilets, and these managed scavengers who have been rehabilitated, working in the insanitary letters, are going to clean the flush letters. So I don't really feel where if you read the preamble of the Act 2013 Act, it talks about it apologizes, and it also says that these people have a dignity. So you need to respect that, right? So so what is the policy formulation? Who is making the policy? But that is a big question. So in the policy making, the workers also should be part of the process, and also involve the grassroots workers who have been engaging with these workers for a long time also to be part of the policy framework, because they will know better than the state, because it cannot happen in the four walls. And there is a larger engagement and consider and you need to take their viewpoints as well while formulating the schemes and policies for these works. That is completely lagging, because we fail in most of the policy formulation. We do not engage the beneficiaries. What you need, we never ask that, right? It's only from one side, so it doesn't the beneficiary doesn't have any say in what he wants. So you provide them skill training, what do you have to offer for them, but you never ask them what you want to do. So the case which I shared with regard to the worker was asked to sell perishable vegetables without having the infrastructure. He failed in it. So what? So I think there is there should be a dialogue between the civil society organization grassroots workers, people engaged with the community, the activists, those, including the academicians. Maybe it can be different viewpoints can be taken into consideration when you are trying to formulate itself. And I think it should be fast tracked. Otherwise, these workers will go back. It is like vicious circle. No, you go back. You fail, and again you don't have any other option. You go back to that same profession. So that is all these things have to be taken into consideration when we talk about rehabilitation and compensation. I feel, see, compensation also has I have a point. This judgment came in 2015, 14. It's 10 years now. We have inflation, we have a price rise and all. Can you imagine? Still, we can stick on to that 10 lakh rupee. So there is also a kind of revision that has happened, because we have DNS allowance paid for a worker. Wages has increased. Every government employee is entitled for DNS allowance because of the price rise, inflationary rate. So similarly, I feel that 10 lakh compensation is very less with regard to sewer death, because we have lost a life, and the whole family is the only breadwinner in most of the cases. And we can't say that only 10 lakh rupee can be paid for this person. But it also include, at least provide them an employment, a government employment for one of the members of the family. Provide educational assistance, scholarship, the many things. Doesn't see? I'm really sorry I didn't share this. One of the case studies which I from my own field. There is a scheme for unclean occupation. The national scheme, there is a national scholarship scheme for pre-matric scholarship scheme for unclean occupations like manual scavengers. The sanitary workers and septic tank cleaners children are not eligible for that scholarship. You know why? They don't come under the definition of manual scavenging under the MS Act. So therefore, they're excluded from that scheme. So I think when we talk about unclean, everything is unclean. Whether you're directly or indirectly engaged in this occupation, you should be considered to be part of this community who's been really dehumanized, and they lost the and they have been facing a lot of challenges. I think somewhere when we talk about think about policy formulation, all these things has to be taken into consideration. I think no one should be left out. That's what I think.
Okay. Is it better now?
Yeah.
Better now? Yeah. Okay.
Yeah.
I think that's it from my side. Thank you so much for giving us really good insights into the provisions and the situation, which is like there with the laws and legislations, and like starting from what kinds of occupation like that are excluded in this manual scavenging act. Then what are the loopholes? Then going ahead with the ST and the other alternative statutory, judicial, legislative options, and then talking about like how compensation becomes a major issue, how rehabilitation is not something that has been taken care of in a adequate manner, and it actually becomes a vicious cycle when like people and generations spiral back to that occupation due to the lack of compensation, due to the lack of provisions for them. So and then the fact that they are not even included in the policy making, their voices are somewhere not heard in the process of policy making, and it all has to be taken into account while we go ahead and like think about these issues. So thank you so much for providing these insights, and it has been really good interacting with you. And thank you again for joining us for this. Thank you so much, sir.
Thank you for this opportunity. Thank you.
Thank you.
Nice.